So I will begin this with an acknowledgement of country. I'd like to begin by acknowledging the traditional owners of the land on which I am presenting from today, the Eora people, and I pay my respects to elders past and present. I also want to acknowledge that the criminal law impacts First Nations people disproportionately. I welcome any participants who are Aboriginal here today and who might be watching the recording. What we will cover today, this is an overview of what we will cover today, words and terminology, about the courts, the criminal process, criminal legal documents, offences, types of sentences, and where to get help with legal words. What we're not covering today, and we will in a future one, is general training for interpreters working in legal settings. Oh, sorry, we won't be covering that later. And interpreters' ethical and professional responsibilities. I was getting ahead of myself there. And what we will cover in a later session is words and terminology about domestic, family and family violence, AVOs and sexual-based offences, which will be covered in our live webinar scheduled for the 6th of May, and you are very welcome to join us and register for that. Okay, so context is important. And understanding the full picture is important so it can be meaningfully interpreted or translated into another language. And so there is full understanding and no misunderstanding. In advising and teaching what the law says in respect to criminal law, we are trying to equip you with knowledge of the law, but also the language and the context the language is used in, so you can then most effectively and accurately translate and interpret that into another language. Some of the scenarios you may be asked to interpret in these matters is for an accused person at a police station to explain their rights, or when they're being interviewed by police, or they are in conference with their lawyers, or in court in front of the judge, jury, prosecution and defence lawyers. For a complainant, the person making a complaint is you could be asked to interpret in making a statement to police, having a conference with prosecution lawyers, or in court in front of the judge, jury, prosecution and defence lawyers. Okay. So, criminal law, I will now hand over to Helen. As I've said, today's focus is to assist people who interpret in criminal law settings. And criminal law is the largest part of legal aid work and the largest section of legal aid. The criminal lawyers at legal aid assist people, including Helen, charged with criminal offences appearing before the courts. We also have specialist services, including legal service and a youth hotline. But we will just be talking about the adult criminal law today. If you interpret for young people in the children's court, there are some differences. We also have specialist services, including drug court and prisoners legal service. We're interested to know about your experience interpreting in criminal law settings. So I will do a quick poll. You can answer this using your keyboard and clicking on an option, or you can just type in your question panel. Okay. I think maybe I'll just get people to answer in the Q&A box because it'll be easier so we don't get behind. And I will hand over to you, Helen, and we'll start with the criminal courts. Thank you.
Okay, so hi everybody. If there is some echo, sometimes that's caused by a mobile phone being near the microphone or the computer. So if some people have said that they've got some echo in, so maybe just switch off your phone perhaps, or move your phone away from your computer if you're on the laptop. Hopefully that helps. Hopefully the problem resolves. I just wanted to say that, yes, I'm a criminal law solicitor at Legal Aid, and we work with interpreters and translators a lot in many different languages, and I love working with interpreters, and I just want to acknowledge the role that you do. It's essential for communication between myself and clients who I don't have a common language with. And so your role is super important. to facilitate communication and the accuracy that you can achieve. And accuracy in interpreting and translating is essential as well, because it's so important that the person is not disadvantaged in the criminal justice system. So welcome to everybody. And I also know from the enrolments that we also have some students and some student interpreters, as well as student lawyers, so paralegals, etc. So welcome to everybody, and it's wonderful to also have people from interstate and abroad. Though our focus is New South Wales, so there might be some differences in your jurisdictions, but welcome to everybody. So in Australia, in New South Wales, the terminology, every criminal charge starts in the local court, what we call the local court, regardless of whether it's state offence, Commonwealth offence, murder, common assault, shoplifting, everything will start in the local court. More serious matters will go to the district court, like aggravated robbery or large drug supply matters, for example, state matters. Murder matters and terrorism matters and some very large tax fraud matters, for example, will go to the Supreme Court of New South Wales. And then there is the the Court of Criminal Appeal, which is a subdivision of the Supreme Court. And there are 3 judges usually that hear appeals against conviction or appeals against sentence from the District Court or the Supreme Court. And then across Australia, the highest court in the country is the High Court of Australia, which receives a few appeals each year from around the states and territories of Australia, but it's very hard to actually for an appeal to be accepted to the High Court. They only deal with certain matters, and that's usually a 7-judge bench hearing the appeal. We have statute law, which are parliament or politician created laws, statute law and common law. Common law is sort of built up over can be hundreds of years, back in England, where New South Wales borrowed from the UK, the British legal system, and those customs and traditions and everything have created the laws and traditions, but the statutes are parliament made, politician made laws, and statutes are acts of parliament, and statutes are frequently updated as well. So we're dealing a lot with the Crimes Act and Drug Misuse and Trafficking Act, Criminal Procedure Act. Those are all politician created laws, parliament created laws, which in criminal law we're using all the time. So that's a bit about the hierarchies and the types of laws. So the criminal process starts with police arresting a person, and police will lay charges for an alleged offence or offences, and the police can either choose to give somebody bail, release them on bail to come to court on a future date, or police can refuse bail and the person will have to be brought to court as soon as possible, maybe the same day, or it may be overnight the next day, to apply for bail if the person wishes to apply for bail. So the word remand, a person is remanded in custody if they are not granted bail. They're remanded in custody. And the way that the word remand is also used is somebody will be on remand if their bail refused, awaiting for their case to be finalised, whether that's by defendant hearing, trial, or pleading guilty and going to sentence. But before their matter is finalised, if they're in custody, if they're in prison, they are on remand. And so that's the criminal process. And of course, people going to court through the court system, through those processes and that hierarchical court system as well. And I can't see on the slide there, but we do have people enter a plea. There's a little picture missing that I can't see on the screen, but people enter a plea to the charge, a guilty or a not guilty, or some people are not fit to enter a plea. And if people plead not guilty, then they go to trial. Okay, the blue is coming up now. People go to trial or defended hearing if it's charges remaining in the local court. If people plead guilty, then they go to sentence and get the punishment of some description. And we'll look at sentences later in this presentation. So arrest and police interviews. The role of police is to investigate, and the role of the lawyer, interpreters and support people at the police station, if not every person has a lawyer at the police station, but interpreters are frequently required to go to the police station or speak to a person over the phone. You might be called up to translate a document explaining the person's rights, custody by the custody manager. So there's a document which every person in custody is given before they're charged, their right to silence, their right to speak to telephone a friend, those sorts of rights. And as an interpreter, your first role in the criminal justice system might be to do that interpreting or translation of the document on the spot at the police station or over the phone. Sometimes people will be given the opportunity of a support person if they're a particularly vulnerable person. If the police, hopefully, they recognise there is a cognitive impairment. Aboriginal people are supposed to be offered a friend or a support person. Children, persons under the age of 18 are supposed to be given a friend, parent, guardian to be at the police station with them. And the person in custody at the police station may want to speak to a lawyer by phone or the lawyer in person and give the lawyer some instructions. The police are supposed to inform the person of the right to silence, that they don't have to participate in the police interview. If the police do if the person does choose to participate in an interview with their lawyer present, then they're given what's called a special caution. And the UK system, if you watch UK television, British police shows, the way that they caution people is like if you fail to say anything in your defence, basically you may not be able to use it later. You may not be able to raise that issue later if you fail to say it now. That's the kind of special caution that people in New South Wales get if they have a lawyer present at the police interview. Most people don't have a lawyer present when they're interviewed by police. The acronym ERISP, E-R-I-S-P, stands for Electronic Record of Interview with a Suspected Person. So somebody's been arrested, they're a suspect, they're under investigation, police want to interview them, and it is electronically recorded, audio and visual. In the past, there were no visual videos or audios of the electronic record of interview with a suspected person. Police interviews were not videoed or audio recorded, and there was always allegations of police brutality, police forcing confessions, things like that. The electronic recording of this shows you should be able to get a visible image to see whether somebody looks like they've been assaulted, if the bruising has come out, because that has happened in the past. It's not unheard of. And also, if somebody's upset, you can see it and you can hear it. You can also hear their voice, and you can see and hear what the police question actually is and what the person did or did not say. And as an interpreter, if you are in the police station when somebody is being interviewed, you will be seen and heard, whether you're on camera just at the side or not. That you may not be always seen, but your interpreting will be recorded and heard, which is very important. ROI is record of interview. It's the same thing as the ERISP, just a different way of saying it. And inducement uh, is like pressure or a promise, sort of like a promise or a incentive to confess, for example, or to make admissions, to say something. So at the end of the police interview, an independent police officer will come in to the interview room and ask somebody whether they have been given a promise or an inducement to participate in the interview today. And hopefully the answer is no, because if somebody has been made a promise by police or an inducement or given some sort of a deal or an incentive to talk, then that could invalidate the whole interview process. So COPS, COPS is computerized operational policing system. That's the system, the computer system that the police themselves use. And when something is reported to police, whether there's a charge or not, it's given an event number or a reference number. And sometimes police will give a person a card with an event number on it as the reference. So every matter, every report of whether it results in arrest or charge or not, will have an event number, and it should be recorded in the police computer system. H number. You'll hear this a lot in the local court when you're interpreting. You'll hear the judges, and I specifically say judge because in New South Wales we no longer call the magistrate magistrate. We now call magistrates judges, as well as judges in the district court, judges in the Supreme Court. Judges in the Supreme Court are called justice. But back to the H number, on the top right-hand corner of every police fact sheet is an H number, and that is the police reference number. So every arrest will have an H number. It's a reference number, and somebody might have 3 different separate arrests, 3 different separate robberies, and they will each have a different H number. So it's a reference number, and police use those, the courts use those. And often in court, you may hear the judge saying H number ending in 608. And so the lawyers will be looking at the paperwork, finding which document, which set of charges the magistrate is looking at. I keep saying magistrate, the judge is looking at right now. It differentiates the separate sets of matters. That's H number. I don't know why it starts with H, it just does, but that's the police generate those numbers. Sequence, again, in the local court, you'll hear sequence used a lot. On one H number, on one reference number, somebody might be arrested for 5 offences at the one time. There might be a robbery, an assault, obtain money by deception, goods in custody, an assault police officer, all on the one charge sheet, all on the one police facts. You'll have 5 charges and under the one reference number or H number, and you'll have sequence 1, 2, 3, 4, 5. If the prosecution, that be it the police or the Director of Public Prosecutions, withdraws a number, withdraws a charge, they might tell the judge, the Crown, the prosecution is withdrawing sequence 3, for example, which is charge number 3 on that fact sheet, and the defence might indicate that they're pleading guilty to sequence 1, the first charge, not guilty to sequence 2, the second charge. So you'll hear the word sequence a lot. It is a specific charge in that list of charges. Statement of facts or fact sheet. So every time a person is charged with something, police will type up what's called a fact sheet with their summary of the allegations against the person. And it might include a bit of a spiel about the person's criminal history and why police suggest to the court that this person should be refused bail. So there'll be other stuff as well, not just the summary of the allegations. That document is handed up, is on the court file. It may not reflect the entire brief, so more documents will come in later. If the matter is going to be going to the higher court, there will be more documents served after that police fact sheet. But when somebody makes a bail application, the fact sheet is what is handed up to the court on a bail application. It's written by police. It may or may not be 100% accurate in its reflection of what the actual evidence ultimately is. Without prejudice is something that as lawyers we like to write on our correspondence if we're making an offer to plead guilty perhaps to a less serious charge, maybe something that the prosecution haven't yet laid, a charge that the police did not lay, but we might read the material and under instructions be told to offer a plea of guilty to a different charge or a less serious charge. And we might say without prejudice and without admissions. So, you know, testing the water, would the police or would the DPP lawyers be willing to accept the plea of guilty to this less serious charge? We're not admitting anything at this point, but what would be the response if would you withdraw the robbery and would you accept the plea of guilty to a larceny, for example, and without admitting anything at this point in time? So it shouldn't be held against. If the offer is rejected or the client changes their mind, then it shouldn't be used against them in future negotiations. Okay, so bail or release applications. So there's a bail act, and the other phrase is release. Bail or release applications. Applying to have somebody released on bail is essentially what it's about. So bail is usually with conditions. It's conditional liberty in the community under conditions. There might be various conditions on the right-hand side. You can report to police, do not associate with certain people, example, the co-accused or witnesses for the prosecution, don't go near victim of crime, don't contact them. There might be a curfew, an overnight curfew. And surety might be a person, either the individual themselves who's been charged or an appropriate person like a family member or somebody that is offering money to forfeit money or property if the person fails to obey their bail conditions, especially if they fail to turn up to court. Bail is decided, there is the Bail Act 2013 in New South Wales, and it keeps getting updated frequently. So there's been many changes since it came into effect, and it's decided by a court, by the local court, but can be decided by police first off or not. Then the local court may make a decision on bail, grant it or refuse it. Supreme Court people can go to the Supreme Court to make an application for bail if they've been refused in the local court. If somebody makes more than one application in the same jurisdiction, example, the local court, there have to be significant reasons. There has to be a change in circumstances, something different for the next application. Otherwise, the judge can refuse to hear the application if there's nothing that's changed, if there's nothing different. Some people, if they've represented themselves on their first application for bail, then that can be a reason to make another application for bail in the local court, this time with a lawyer. So if they did make an application after arrest at the first court appearance without a lawyer, then that can be a reason under Section 74 to justify giving them another chance at bail. It's up to the judge whether they agree that there's something different this time, something that changes the circumstances. So sometimes we somebody might have got a place in rehabilitation centre, and you might not have had that document or that placement available the first time the application was made. So you try to apply for bail to go to rehab the next time. To me, that would be a good reason, reason to apply for bail again in the same example, local court. But, a magistrate might disagree with that. They might say, well, no, that's not good enough change, or it's not going to it's not materially different to the last time you applied. So you're really at the mercy of the court as to whether they'll give you another chance at that level. The problem with Supreme Court bail is the waiting time is really long. So you can get a hearing date much quicker in the local court, but you have to make your application. If you're going to, don't waste the opportunity, and that's what I say to the client: don't waste the opportunity. Make it a good one the first time, because otherwise it's wasted. Show cause is a part of 16B, Section 16B of the Bail Act, and there's a list of factors which can make a charge show cause. For example, somebody might be on parole at the time that they committed the new offence, and if they're on parole, then that will make the new offence a show cause offence, and it makes it harder to get bail if you've got an additional hurdle to be granted bail if the offence is what's called show cause offence. And there's other reasons, like something carrying life imprisonment, terrorism related charge. There's a whole list of factors which can make an offence show cause under Section 16B of the Bail Act. And some things which are very serious are not show cause. There's some quirky things that happen, something you think would be show cause, isn't, and sometimes what looks like a relatively minor offence becomes show cause because of, example, the person was on parole at the time. So it makes getting bail harder. And on bail, everybody's criminal record goes before the court, so the court can see the whole history of offences, and every fail to appear in court in the past comes back to burn you the next time, because the court will think, well, there's a potential this person may not appear in court this time. So there's these risks that the court must look at. What's the risk that this person will fail to appear? Well, let's have a look at their criminal history. Do they have a history of failing to appear? Let's have a look at community safety. Is this person a risk to the community safety? Let's have a look at what the actual charge is this time, and let's look at what their criminal history is. is the person at the risk of reoffending or committing a serious offence, committing an offence on bail? Let's go back and look at their criminal history. Do they have a history of breaching their bail conditions? Do they have a history of um, committing offences while on bail? And their criminal record will show breach of bail, breach of bail, breach of bail. It makes it harder to get bail the next time. So the court has to look at, is this a show cause offence? Yes or no? Is this a second application as well in the same jurisdiction? Yes or no? Should this person be given a chance? Do they get over this hurdle? Because show cause, you need special, sorry, not special, but you need more reasons why you should be given a chance at bail before the court will then look at what those risk factors are. And if the risks are considered able to be overcome by conditions like curfew, reporting to police every day, don't associate with certain people, if the risks can be mitigated or resolved or lessened by certain conditions, and some bail is extremely strict, then the court should give the person bail. But if the court is of the view that nothing can satisfy the court that this person will turn up, that this person will not reoffend on bail, that, etc., then bail will be refused and the person is remanded in custody. There's that word again, remanded in custody until the next court date. So it's a bit about bail.
Helen, just one question's come in about the bail. How would we know if it's a second attempt at a bail application? Is there different wording used?
The lawyer will have to address, or the court will ask, is this Section 74? So the court paperwork will have whether this is the first attempt at bail, second attempt at bail. The lawyer speaking to the client will see on the file, the lawyer will know whether this is the first or second attempt. The prosecution or police will know if an application has already been made, and then that Section 74 of the Bail Act will become a live issue. And that will be the first hurdle that the judge will deal with before they look at show cause or before they look at the risks. So Section 74 becomes the first hurdle.
Mm-hmm. Thank you.
Okay, so now we have some words. These are words to do with people at court. And as you can see, we've crossed out magistrate because in New South Wales, we no longer use the word magistrate in the local court. They are now called judges. We still call them Your Honour. So Your Honour for local court, Your Honour for district court, and Your Honour for Supreme Court. We also have registrars, and they are not judges, they're not magistrates, they work in the courthouse, and they will often deal with mentions or adjournments for getting a next date before any plea has, or they might, sorry, I should say somebody might indicate to the registrar that they're going to plead guilty today to the charge, and the registrar can be at different court levels: local court, district court registrar, Supreme Court registrar. In the local court, if the person or their lawyer indicates there will be a plea of guilty, then the paperwork will be sent to a different court to be dealt with on that day. It might be ready to proceed immediately, or if they want time to collect some character references or documents for their sentence, then the registrar can adjourn to a different date. So I was just in the registrar's call over on Monday for a matter which I had put in representations without prejudice and without admissions to police prosecutors, and waiting for a response. And because I'm still waiting for a response for my client, the registrar adjourned the matter for several weeks to wait for police to answer whether they will withdraw the charge that I'm asking them to withdraw and accept the plea of guilty to 2 of the other charges. I mentioned justice, so justice of the Supreme Court. They're a judge, but they're called justice of the Supreme Court. And judge, so judges are in the local court in New South Wales now, and also district court judges. Lawyer, so magistrates in other jurisdictions, judges, they're all lawyers. They all have a law degree. Solicitors and barristers are also lawyers. They have a law degree and they practice law. They have a practicing certificate to practice law. So that's what lawyer is. Solicitor, which Melanie and I are, we're solicitors. We've got a law degree. We practice law as a solicitor. We go to court, or solicitors don't all work in litigation roles either. So banks have solicitors that may or may not go into court to litigate. So you have solicitors in very different legal roles across different corporations and organisations, but basically do have a law degree. As a solicitor in criminal law, I do appear as advocate in sentences and run local court hearings, bail applications. I usually instruct a barrister in a criminal law trial. So again, a barrister is also a lawyer, and distinguishing them in court. In the local court, you can't see who is a solicitor or barrister by what they're wearing, because in the local court, the barrister does not wear their wig and their cloak, their black cloak and vest. But in the district court and the Supreme Court, the barrister does wear the wig and the black cloak and vest. Solicitor does not wear that sort of clothing. So visually, you can tell the difference in the district court or the Supreme Court, who is solicitor and who is barrister. There is senior counsel and junior counsel, and senior counsel is also called King's Counsel with the King Charles now on the throne. It's King's Counsel. In the past, when it was Queen Elizabeth, was Queen's Counsel. So so solicitor can still do the same advocacy as a barrister, but very often in a trial, in a district court or a Supreme Court trial, solicitor will hire a barrister, instruct the barrister, and the barrister will be the one that cross-examines the witnesses, makes the oral submissions, legal arguments, etc., and has the speaking role in the trial. Whereas the solicitor has to keep all the documents, give the barrister all the documents, a lot of the behind the scenes work, document-wise, also checking transcripts, keeping track of all the exhibits, etc. That is the solicitor's job, and the solicitor is a bit more of the middleman, so to speak, between the client and the barrister. So the solicitor hires the barrister. The solicitor often speaks to the client more than both with and without the barrister, but the barrister won't talk to the client usually without the solicitor present. So the solicitor kind of is in the middle between the two, client and barrister. Associate is an assistant of the judge, and often many associates are studying law or have law degrees. They may not have practiced law yet, but many of them are studying law. Not all, but many are. And they assist the judge. They keep track of exhibits. They might do a lot of the research as well for some judges. That's the associate, and you can see them in court and any email correspondence is done between lawyer and associate, not directly to the judge. Police prosecutor rank is a sergeant, and they will not be in police uniform in court. They'll be in a suit, and they will be sitting at the bar table at one end and with a stack of documents for local court. They're in the local court. So they will appear on sentence, bail applications, busy list days where matters are adjourned. So that's a police prosecutor. They are a sergeant. Some of them also study law, and some of them later on choose to leave the police force and become private lawyer. So that's police prosecutor. Crown prosecutor is a barrister who works for the Office of the Director of Public Prosecutions or the Commonwealth Director of Public Prosecutions as a Crown prosecutor. Crown comes from the meaning the king or the queen. They're meant to represent the community. Crown prosecutor, they are a barrister. Sometimes the solicitor of the DPP may also be called Crown, the Crown. They are Madam Crown, Mr. Crown. So in a trial, they won't be called by their actual surname. They'll be called Madam Crown or Mr. Crown. Crown is not their surname, it's just referring to them as the Crown prosecutor. Whereas defence lawyers are called by their actual surname. Miss Shaw, Ms. Williams, Mr. X, whatever the name is. Then there's you guys, the interpreters, very important person in court, extremely important person in court, I should say, because without you guys, the client can't understand what the judge is saying or witness is saying, or their own version needs to be interpreted to the court so the court can understand what the person is saying. Very often you may have to go and stand near the microphone while the person might be up on the video link from prison as well, and or you might be in the dock in court sitting next to the person in a trial, or in the back of the court, or you might be at court being asked to go to the cells, the court cells, to interpret in a conference down in the cells, and or interpret with witnesses, etc. So, and you might be in the witness box, witness stand near between the jury and the judge, interpreting for a witness or the accused or the offender if they've pled guilty. Sheriff, they sort of deal with jury empanelments, court security, that sort of thing, the sheriff's office or the sheriff, and they sort of a lot of behind the scenes security and securing the building and all of that, and administrative tasks involved in administration of justice and getting jurors informed about and ready to be brought into court for possible jury selection, that sort of thing, as well as court officers also. There'll be a court officer in every courtroom, and they assist with the technology, which always fails always fails miserably, trying to play videos and things. And the court officer will also ask you if you take an oath or an affirmation and swear or affirm you as a witness, or the interpreter swear you or affirm you before you interpret. And the court officer passes documents around and makes sure and escorts the jury in and out of the courtroom when there's a trial. So the court officer is also extremely important in having everything done efficiently. Jury. So New South Wales has jury trials, 12 people, but sometimes there'll be an extra juror, like 13 or 14 people chosen, and then before the verdicts are, they'll listen to all the evidence, the extras, and then before going to deliberate. The extras, if they're still there, will be removed so that it's only 12 people returning verdict. But sometimes in long trials, they get extra people because very often there might be a juror that becomes sick or something, or asks to be excused for some other reason, and so that the trial does not completely collapse because of loss of too many jurors. But yeah, jury trials in New South Wales, and majority verdicts 11-1 in New South Wales. I'm not sure about other jurisdictions, but that's the situation in New South Wales. Jury trials, under the Australian Constitution, that's the default right to a trial by jury, because it's considered a trial by your fellow community members. That's the idea behind the jury trial, rather than being tried by one judge. But people can elect to be tried by judge without a jury. And sometimes, if there's no dispute on the evidence, or it's very technical psychiatric evidence or something, sometimes, and there's no dispute that the crime was committed, but that the issue might be the person's mental health, for example, or there might be something that's evidence that's going to be way too prejudicial, we think, for community members, like there might be issue of drugs being consumed by both the victim and the accused, but it might be entirely relevant and necessary for the context of the case, but considered too prejudicial for a jury. So that might be a reason why an election is made for judge only without a jury. Juries do not decide penalties, however, I should say. So if somebody is found guilty, juries do not have anything to do with what the penalty or the sentence is. Okay, so common words used in court. We have prosecution and defence. So prosecution can be the police prosecutors, can be a lawyer for the prosecution, Commonwealth or state prosecution. Defence is defence lawyer, can be solicitor, barrister, both, or a self-represented accused person might present their own defence. The defendant is the person that is accused of a crime, and they might be on trial, and there may be more than one. They might be co-accused, so 2 or more persons accused of a crime. Offender is somebody that has pled guilty or been found guilty. They will then be referred to not as the accused, because the accusation has been proven, either because they admitted it, or the jury or the judge found them guilty, or the judge. So offender is somebody that's being sentenced. Co-offender, more than one person, 2 or more, guilty of particular crime, co-offender. If something is fixed for mention, a date is given for that court case in the future. It's fixed for mention. A mention is a very short appearance in court, might be a matter of minutes, and it's usually an update as to what's happening. Have the police served the brief of evidence yet? It's a yes or no question. And then if yes, then we can go on to get another date, adjourn to the next date for the next stage. Mention, it might be, is the trial ready to proceed? And that might also be the call over, the word call over. Is the trial ready to proceed on Monday? Yes or no? And so these are short court appearances. The matter is not finalised. It's not going to be finalised at a mention. It might be a mention to enter a plea of guilty or not guilty, and get a date for sentence, or a date for local court hearing. So the mention or the call over is not going to be where the case is finalised. Hearing a defended hearing in the local court or a sentence hearing in local court or district court or Supreme Court. That's where evidence is going to be presented by prosecution and defence at the hearing. So it can be a defended hearing where the person's pled not guilty. It can be a trial where the person's pled not guilty. A trial will be with a jury or without a jury in the district court or Supreme Court, and or a sentence hearing where evidence is presented about the crime and submissions are made about appropriate punishment and factors that the court should take into consideration, personal factors and factors about the crime as well, so that the evidence is heard, submissions are heard. A special fixture is usually given when often local court or a lengthy district court sentence, lengthy for a particular reason. There might be many co-accused, co-offenders, I should say, or a long local court hearing of many charges, and it's given a special fixture means time is set aside. It should have a guaranteed start. A particular judicial officer has been allocated to the case with might be 5 days in the local court, which is a long local court hearing, that it should proceed on that day. There should be nothing else in court listed in the same courtroom with that matter, and resources should be given to ensuring that that matter is dealt with at that time. Special fixture. There might be a lot of witnesses to be cross-examined, a lot of evidence to be considered. And sometimes, yes, sometimes a sentence in the district court might be particularly lengthy for whatever reason, the amount of evidence or the amount of co-offenders, and it's given a special fixture so that it can happen that day, allocated a particular judicial officer, rather than waiting in the list, is there going to be somebody available? It's given a special fixture. Evidence in chief is when a witness, whether it's a prosecution witness or a defence witness, is giving their version of events. They are asked questions and they answer questions. That's evidence in chief. So for an accused person who is giving evidence, their lawyer, the defence lawyer, will ask them questions in evidence in chief, and the Crown prosecutor or the police prosecutor will cross-examine the person. For prosecution witnesses, whether that is the victim or an eyewitness who saw or heard something, or an expert called for the prosecution, their evidence in chief will be done by the prosecutor asking that witness questions, and then the defence barrister or the defence lawyer will ask questions, which is called cross-examination. Voir dire or basher inquiry. Voir dire is a series of questions in chief and cross-examination in the absence of the jury, with only the judge there. And it might be that the parties there might be something that is a fresh statement that wasn't served before, some fresh evidence perhaps, and the parties are having the opportunity to clarify this or ask a few questions before, without the jury hearing it, and then testing what that evidence, what the answers would be, and then you make a decision then whether you will ask that question in front of the jury or not. It might be, you might get an answer that, absolutely not. Very often this results in the parties did not have this evidence in the local court, and so it wasn't able to be tested earlier, and now is the first time that's able to be tested. But it is transcribed, it is recorded, whatever that evidence is, and then if once that discrete area, a line of questioning, evidence in chief and cross-examination has been made on voir dire, then the jury is brought back in, and the parties will have decided whether that part is going to be excluded, not asked, or whatever. And the jury doesn't know that that's happened. Um, and any evidence that's given, like on a voir dire, in the absence of a jury, the transcript of it, anything that's said in the absence of the jury does not get given to the jury later if they ask for transcripts of trial, because anything said in the absence of the jury, including legal arguments and judges' rulings, are not evidence and won't be given to the jury. So committal hearing, things change. I'm not sure about the other states, or we have a friend from New Zealand. I'm not sure about what happens in New Zealand or the other states like South Australia, WA in Australia, but we no longer have the local court, now called judge, does no longer have the power to throw out charges or discharge matters at committal. The magistrate or the judge, the local court role is much more administrative, but you can still have a committal hearing in the sense that you can apply under limited circumstances to have some witnesses called in the local court, really to test some evidence. Maybe it's an identification issue, and maybe there's confusion over the perpetrator, how they're described, or there may be some expert evidence, gunshot residue, for example, that you want to cross-examine the expert on in the local court to see whether that can possibly be challenged now before the matter goes further to the higher court, or whether you might need your own expert report to try to challenge the expert report that's been served in the brief of evidence. It used to be the case that you might hope to cross-examine some witnesses and achieve a situation where the prosecution would then decide to withdraw charges. That might still happen, or that the evidence would be so weak and crucial to the prosecution case that the magistrate, which was the case when this could happen, would discharge the matter and refuse to commit the matter for trial. That power is no longer present for the magistrate. So matters, so now it's really, you have to decide whether it's strategically worth testing certain evidence at the committal stage. The danger side, sometimes it's not worth it, because sometimes the police or the prosecution will patch up their problems. Sometimes you have to think, if you highlight the problems too early, sometimes they can be patched up and fixed. But basically, committal hearing is, there can be cross-examination and testing of evidence. The matter can also be, you don't have to, most matters that will not happen, and the matter will get to the point where there's been decision by the prosecution on what charges they're going to prosecute, and then the person will enter a plea of guilty or not guilty and be committed or sent or transferred to the higher court, if district court or Supreme Court, for murder or terrorism charges. So in the local court, you're going through that committal process. It's a long process. Brief has to be served. Charges have to be decided. Is the prosecution sticking to the charges that police laid, or laying something different? Sometimes negotiations are successful and charges can be withdrawn, or less serious charges laid in place of the original charges, and then the matter may be transferred or committed to the higher court. We have alibi. It's a type of defence. and it's basically saying that the person was not present, did not do the crime, so not guilty, did not do the crime, and in fact was at a different location at the time. And you have to really put on proof, evidence, you have to serve a notice on the prosecution that you are going to run alibi defense um, at least 42 days prior to the commencement of the trial. And part of that is giving the police a chance to investigate the alibi. Some alibis are going to be very clear. The person might have been overseas and can prove that. Other alibis might be a little bit more murky. Um, and some people can't actually prove that they were not at a place, but it may be a bit more like, well, my usual practice on a Thursday night was to go shopping, so I wasn't at the bank committing the robbery because I was doing what I usually do on a Thursday and go shopping at this centre. Now, maybe there can be CCTV footage proving the alibi, or maybe not. But the idea, you have to serve a notice of the alibi, and the prosecution can try to either verify it or rule it out with evidence. It may be ruled out, and the alibi defense may collapse. The alibi defense, if it's sticks, then it should resolve in the prosecution withdrawing the charge because it's a defense if the person wasn't there and didn't do the crime. So it could result in the charge being withdrawn before it even needs to go to trial. Interim hearing or order. This is to do with AVOs, which will be the subject of our presentation in a couple of weeks on the 6th of May. We're looking at AVO terminology and everything, but interim hearing or an order is it's sort of between the time that the AVO is placed on a person and the final order being made. So it's in the interim, it's in the meantime, temporary, but continuing. And or other types of interim hearings may be interim applications by the Crown Solicitor's Office. These are more civil applications, but connected to past crimes. Applications for extended supervision orders, for example, which are done in the Supreme Court. So somebody is on parole, for example, and the Crown might want to extend their supervision in the community and put on an application, and there might be interim orders made. So in the meantime, prior to the court making a final decision, interim orders, interim hearing and interim orders. Adjournment, stay of proceedings. Stay of proceedings is hard to get on a permanent basis, but one example that it may be achieved is if somebody is extremely sick and not going to get any better. So terminal illness or terminal or a decline in cognitive functioning, unfit for that reason, like Alzheimer's or something like that. It may be the person might be extremely elderly, or their health also may be extremely fragile, and there may be an application for a permanent stay of proceedings. So it's not a not guilty, it's not a withdrawal of the charge, it's a stop, or at least a suspension to the criminal proceedings. But it's hard to achieve. And or it might be a stay of proceedings until somebody can save up more money to afford legal fees. Now, at Legal Aid, we don't charge people legal fees. We don't charge people for our representation, and they may have to make a small contribution, not to the lawyer, but to the organisation. But in if somebody is privately represented and they're paying money, if they've run out of money, then they may apply to the court for a stay of proceedings until they can apply for either legal aid to fund their matter, or they may apply, if they're not eligible for legal aid, they may apply to save up money so that they can pay the private lawyer more money, but they may need to work some more to do that. Proceeds of crime is often connected, it's money or assets bought with money, which is connected to crime. Example, somebody selling illegal tobacco or illegal drugs may make a lot of money and buy a house or buy a car or buy jewelry, etc., with the illegal money that they've achieved by doing the crime. So that's proceeds of crime, and the authorities, whether it's crime commission, police, etc., they can lay charges like knowingly deal with proceeds of crime is a criminal offence, or recklessly dealing with proceeds of crime is also an offence, but they can also make a civil application in the court for forfeiture of that proceeds of crime. So forfeiture application in court to have the court seize that proceeds of crime. There can also be, so confiscate the money, forfeit the money or the asset bought with that money. And there's also forfeit, like drugs are forfeited, and there's applications to have the drug destroyed, that sort of thing. So though they are civil, and some people defend those applications. They say, well, it's not crime money. In fact, it's my Centrelink money, or it's a gift. And if they can prove that it was a gift by somebody or that it was a loan by somebody, they really need to come up with that evidence to where did the money come from and is it legitimate? And if they can show that it's legitimate, then they may get the money back. The forfeiture application may fail. Jurisdiction has a couple of meanings. Jurisdiction can be the location, like South Australia, New South Wales, New Zealand, Australia. That can be the jurisdiction. The jurisdiction of where the court case will be held. The jurisdiction can also be the level of court, the local court, the district court, the Supreme Court. So courts will have to make sure that they've got the power to hear the matter. Sometimes, should this be in the local court? Should this be in the district court? Should this be in the Supreme Court? With drug importations into Australia, which state is going to hear the Commonwealth prosecution of that matter? Where the drugs landed, where the person flew into, which airport the person flew into for drugs, that sort of thing. That will determine which place the prosecution will be commenced. So that's jurisdiction. And does the court officer, does the judicial officer have jurisdiction to hear the matter? International as well. It should, if something's exported illegally or something's imported illegally, which jurisdiction will the crime be prosecuted in? Which country, even with the international law, jurisdiction can also be an issue. Jurisdictional error. So there's a mistake about the jurisdiction. There's a mistake about which court or which judicial officer had, or which venue this should have been prosecuted in. There might be an error, and it might make the whole decision invalid because of the error. Or, if district court didn't have the power to hear something and it should have been heard in Supreme Court or should have been heard in local court, then there's going to be a problem with the validity of any decision made. Judicial error is a mistake by the judge. It's an error by the judge, and judicial errors or legal errors can be appealed. Um, or an allegation of a judicial error might be the basis of an appeal to a higher court. The error should be about the law, not so much as of a fact, because there can be different views about finding a fact. But if the judicial officer has made an error about how to apply the law to a fact, then that might be a reason to appeal. And an appeal can be appeal against severity of a sentence, the length, for example, severity might be the length of a prison sentence, or it might be the type of penalty might be considered too severe. Maybe somebody says they shouldn't have got jail, they should have got an intensive correction order to serve in the community, or somebody might appeal against the length, the severity of the amount of community service hours that they have been given by the court. So severity appeal. Conviction appeal is an appeal against being found guilty. It's appeal against conviction. All grounds appeal is both an appeal against conviction and appeal against severity of the sentence. And so district court will hear appeals against conviction or severity or both from the local court. So you go from local court to district court. And if somebody in the district court or the Supreme Court wants to appeal against conviction or severity, they have to go to the Court of Criminal Appeal with 3 judges listening to the appeal. Break time.
We'll just take a 5-minute break, give Helen 5 to 10-minute break. I think we'll make it 5 minutes. We're running a tiny little bit late, so grab a cuppa, go to the bathroom, and we'll meet you back here at, let's say, 10:50, and give Helen a little bit of her voice a little bit of a break. Thanks. Hi, Helen.
Hi.
Okay, thank you. It's been great. There's a couple of questions just about uh, um, an Auslan interpreter has asked if, when doing an interview with the police and a phone call is allowed, do they get the right for an Auslan interpreter or a video call when on bail?
It's a very good question. I mean, I would hope that it's a video call if it's Auslan. I don't know. Um, the police, you should ask the police that video. I mean, point out the necessity
Mm,
for the video so that the person can see the Auslan interpreter and the interpreter can see, because obviously the visual is important, is essential in Auslan. So
hmm
the police should facilitate. Otherwise, giving an audio is not going to work for the person. So I was curious whether you've had pushback by police in facilitating a video for the person that needs the Auslan interpreter. Yeah.
mm.
There was another question, Melanie, about how do people register for the May webinar?
Yes, yes, that is on our website, but I can also send the invitation out to the registrations on this one as well, as we will. So they'll be
Perfect.
sent an email and that'll have the link.
And yes, so yes, this is recorded.
Yeah.
Somebody wanted to know where they'd be able to find the recording, and also we can email you the slides as well.
Yeah, we can definitely. I think the people that are registered will be emailed the recording anyway, and the recording does go up on you if you subscribe to Legal Aid's YouTube. It's there as well. All right.
Okay, so let's continue. Okay, so we've got summary offence is a charge, which a crime, which is less serious and will be finalised in the local court. There's a Summary Offences Act, and so these things, the chance of going to jail on these is very remote, and they'll be dealt with in the local court. They will not be taken up to district court or certainly not Supreme Court. Indictable, indictment, and indicted. So those three words there. Indictable, an indictable offence is something that a crime which carries a 2-year maximum penalty or more. And that's a lot of charges when you actually look at the maximum penalties in the Crimes Act. For example, a lot of things have a 2-year maximum or more. It's rare to be given the maximum penalty on anything, but that's what the definition of an indictable offence is. An indictment is a document with the charge or charges written on it. It's produced by the prosecution lawyer with the charge written out on it. And the court copy is blue in colour. And as an interpreter, if you are in the district court or the Supreme Court interpreting, at the arraignment, which is another word that I'm going to explain in a minute, the charge will be read out to the accused person, and read the judge's associate or the judge themselves will read out the charge on the piece of paper, called the indictment, and they'll ask the person, how do you plead, guilty or not guilty? That's the arraignment process. As interpreter, please make sure that the defence or the prosecution give you a copy of that indictment as you stand either at the microphone speaking into the microphone for somebody on video link, or you might be standing in the courtroom next to the person who is being arraigned, so that you can read the charge that is being read out by the judge or the judge's associate. it assists you. So you can ask for a copy of that. They should give you a copy of it. You shouldn't even have to ask, but do if it hasn't been given to you. Because there's the technical wording, on the 7th day of May in the year 2025 in the suburb of Blacktown, Mr. X did commit robbery against Ms. Y in the sum of $2,000. How do you plead? Do you plead guilty or not guilty? And then Mr. X says guilty or not guilty. So that's what the indictment is, literally a piece of paper with the charge or charges written on it. The person is indicted on those charges. That means the prosecution has presented this indictment. They're presenting the charges to the court, and the person is arraigned by entering their pleas of guilty or not guilty. The arraignment is that process of having the charge read out and entering the pleas of guilty or not guilty. A deposition it's like a sworn statement. It can be recorded, video recorded. It can be on paper or both. But it's a sworn or affirmed statement, and it becomes evidence, can become evidence. Sometimes in American shows, you will hear that people are going to make depositions, and you might see the show where they've got the video recording. They might be asked questions as well. They may be asked questions back and forth, and they make a deposition, video recorded deposition, or it can be a document like we create affidavits as well, very common in family law as well as criminal law and civil law as well. It's evidence, it's a statement, it's sworn or affirmed by the person making the statement, and that can also be the deposition, and it becomes evidence. Acquit or not guilty. So a verdict of not guilty is an acquittal against. So if a jury acquits a person, or the local court judge acquits a person, the person is found not guilty. It doesn't mean innocent. There's a difference between innocence and not guilty. Not guilty means that the prosecution failed to prove the guilt of the accused beyond a reasonable doubt. It's different to saying that somebody's innocent. But to acquit somebody means to find the person not guilty. Penalty is when somebody is sentenced for a crime, they're given a penalty. That penalty might be jail, it might be a fine, it might be a good behaviour bond of some description, like a community correction order, an intensive correction order. That's the penalty. Custody has a couple of meanings. A person can be in custody. That means they're in jail or at the police station in police custody. If they're at the jail, then they're in corrective services care and custody. Somebody might also be remanded in custody, meaning their bail refused, they're held in detention of some description, they're in custody. Somebody might also have custody of a knife. They're in possession of a knife in a public place. That's a charge. Custody of a knife in a public place. So it's custody. Verdict is a verdict of guilty, a verdict of not guilty, or it might be a majority verdict. It's a decision by the court judge or by a jury, whether guilty or not guilty, or unable to decide, split, that might be a hung jury. A majority verdict is where in New South Wales, a majority verdict is not invited until at least 8 hours of discussions or deliberations by the jury. after all the evidence has been presented and the judge has explained law and legal rules to the jury, a majority verdict has to be 11 jurors to one, either 11 saying not guilty and one saying guilty, or 11 saying guilty and one saying not guilty, but only after 8 hours of trying to become unanimous. Unanimous verdict is all 12 agreeing on the verdict, not necessarily reasons for the verdict, but all agreeing on the verdict. So, verdict is a decision about guilty or not guilty. Sentence, sentence is the can be the penalty, can be the sentence, can also be the punishment. Or you can have a sentence hearing where all the evidence is given, presented, heard, and then the judge will make a decision about what penalty or what sentence to give. Is this going to be jail? Is it going to be a fine? Is it going to be a community correction order, for example? So that's the sentence. A head sentence is the maximum that the court imposed. So it might be a 2-year head sentence with a non-parole period or a minimum term of 18 months. The non-parole period of a jail sentence is the minimum time that the person will have to spend in custody, in jail. It's you don't get less time for good behaviour in Australia, in New South Wales. The court sets a non-parole period, and the rest of the time will be on parole. So, example, 2 years, a 2-year sentence, a 2-year head sentence with an 18-month non-parole period will mean the person must serve 18 months in custody, in jail, and then the last 6 months will be on parole in the community under supervision. That's how the sentence that's how that sentence is split between non-parole period or the minimum term and the head sentence or the parole period is the total. The head sentence is total of non-parole plus parole equals head sentence. A black direction, black is the name of an old case, and it is when the jury have written a note to the judge and they've said, we're stuck, we cannot come to a unanimous decision, we can't agree. Then the judge will give them some advice, some direction, a shove, a bit of a push and shove to say, well, try harder, listen to everybody, look at all the evidence, listen to each other's opinions, try to come to a unanimous decision, a unanimous verdict. Try a bit harder, go away, think about it more. So that's a black direction. It's an urge to come to a unanimous decision. If they still can't come to a unanimous decision and they write another note and they say, look, we're still stuck, then the judge will urge them, well, okay, well, if you can come to a majority verdict, it has to be 11 to 1 though. It can't be 6 and 6. So it can't be 7 and 5. It can't be 8 and 4. It can't be 9 and 3, keeping in mind there's 12 jurors. It has to be 11 to 1. And if you're that stage, if that's how you're stuck, 11 to 1, then you can return a majority verdict. If, however, they're more split than that and they come back with a note and they say, look, no amount of discussion is going to get us to majority or unanimous, we're really divided, then the judge might say, well, no more time is going to achieve anything. So hung jury, discharge, send the jury home. It's a hung jury, and then the prosecution have to decide whether they will prosecute again or withdraw the charges. And many cases do go to retrial with a new jury and often a new judge. So duress it can be a full defence in some charges. There might be a threat of violence, for example, or a threat of death if somebody does not do something. And sometimes drug cases have this come up, duress, that if you don't import the drugs or if you don't courier the drugs from this place to this place, then your family will be hurt or you will be hurt. And so the person may do the crime under duress. But the burden will be on the person that claims that there's duress, giving that evidence and if supporting it if they can. Duress can also be not a full defence to a crime, but certainly it might be taken into consideration on sentence. So it may not have resulted in total inability to choose not to do the crime, or it may not have been such a degree that that the threat was going to be able to be carried out, or it may not justify it in any way as a full defence, but it may certainly be relevant on sentence as a mitigating factor. Okay, so more words. We have to charge as a verb, to charge. So police charge somebody with a crime. A charge is also a noun, and a person can be facing a criminal charge or charges. And yep, charged by police. So a person is charged by police with a particular crime or allegation. Form 1 offences, you will hear this in sentence matters. It is a crime which an offender is admitting their guilt to, and they've signed a document asking the judge to take that crime that they're admitting their guilt to into account when they are sentenced for another crime which is on indictment. So, for example, you might have a break and enter offence, and which the person is pleading guilty to and going to get a punishment for, with obtain money by deception resulting out of the credit card that they've stolen in the break and enter, and they've gone and used the stolen credit card at the shop, and they've tap and go, tap and go, tap and go 10 times, and obtained basically a benefit. They've obtained goods or money fraudulently because it's not their credit card, but that offence might be admitted but placed on a Form 1 and taken into account when they are sentenced for the break and enter offence. The advantage to the offender, to the person that's getting sentenced, is that they're not given a separate sentence for the Form 1 offence. They're not given a separate additional sentence for the crime that is placed on this Form 1 document. So that's an advantage to the offender. Sometimes the prosecution will agree to put an offence on a Form 1 when there's some weakness in the evidence. They might have a problem taking it to trial, but by the same token, the accused person may not wish to risk going to trial on that because, you never know, though it may be a bit weaker, it may still result in a guilty verdict. So sometimes the prosecution will agree to put something on a Form 1 if it's a little bit shaky and a little bit perhaps not the strongest case for them. A backup charge is, for example, you have a supply prohibited drug and you have a possess prohibited drug. So a person is in possession of drugs, and police might allege that they are intending to supply those drugs to other persons. They haven't been caught supplying it, but there's a large enough quantity, according to police, to suggest that this is not for personal use. So the police lay 2 charges for the same set of drugs, a supply charge and a possession charge. The person may plead guilty to possession and deny the supply, and maybe the prosecution will withdraw the supply charge if the person can make a case to say, look, I use drugs myself and I'm not supplying them. This is for my personal use, and I've bought in bulk to save money, and I will use this over the next month. So I'm guilty of possession, but I'm not guilty of supply, for example. Usually the backup charge is a less serious version, is a less serious charge than the charge that it is backing up. That's just one example of a backup charge. Another backup charge might be you might have intentionally inflict grievous bodily harm with recklessly cause grievous bodily harm as a backup charge. Reckless is the mental thinking, which is less serious than intending to do something. So police may lay 2 charges, but only one will be the final charge. One will be withdrawn. The more serious ones usually withdrawn. Sentence assessment reports are something that the court orders. It may be at the request of the defence, or maybe the court themselves want it, regardless of whether the defence want it. SAR, or Sentence Assessment Report, is a report written by Community Corrections, which is the new name for parole officer. They work for corrective services and they supervise people in the community on parole or on intensive correction orders or some other types of supervised orders. And they can randomly drug test people, etc. They also refer people to different courses. So sentence assessment report is written by the officer, goes straight to the court. It addresses the crime, the attitude of the person towards the offence. Have they expressed that they're sorry for this or not? Does the writer think that they're genuinely sorry or not? And it might also suggest types of treatment or courses that this person needs. And it will also assess suitability for community service. And the court may request an assessment for suitability for home detention, which also will involve an ankle bracelet monitor. So you can't get a community service component to a sentence or home detention without an assessment report by community corrections saying that you're suitable for it. So those are reasons. If that's something that the person that the court wants to look into, then the sentence assessment report is necessary. And as an interpreter, you may be asked by community corrections to interpret when those verbal assessments are being done of the person at the office or via video link at jail. You might have to interpret for community corrections when they're preparing a sentence assessment report. Agreed facts are something that is agreed between prosecution and defence about the crime. So somebody has pled guilty and the facts that the court is going to receive are agreed, and that will be the basis that the court sentences the person on. This is a summary of the crime, and it saves the court a lot of time. Instead of reading 15 folders of documents that were the brief of evidence, the agreed facts summarise the evidence of the case, and that's what the court will use when the person is sentenced. It makes it much more efficient for everybody if the facts are agreed. Attempted, so a crime can be an attempted crime, an attempted murder, an attempted break and enter. It hasn't been achieved, but it's been tried, it's been attempted. And the attempt will usually be the same maximum penalty as the actual attempt, but the same maximum penalty at legislation will usually be applicable. However, except for attempted murder, there'll be attempted murder by various means. It might be a choking, a strangulation, a poisoning, that sort of thing. The attempted murder will have different maximum penalty, but obviously an attempt of any crime is still serious, but then the actual sentence, uh, though the maximum penalty may be the same, at law, the sentence will be different to the type of crime that's actually achieved. But the attempt is the intention is still there. The attempt has still been made because the intention is still to do the crime is still there. So sometimes you'll see the charge with attempted in brackets next to it sometimes, or you read through the facts and you realise that it's been attempted. It hasn't actually been achieved. Actus reus and mens rea, these are Latin words, so law obviously borrows a lot from Latin. Actus reus is the action and the actual physical act, and mens rea is the mental thinking, so the mental state, the mental element of the crime, whereas actus reus is the physical element of the crime. So mens rea, the intention to do something, was it intentional? Was it reckless? Those will have different penalties. The actus reus, the actual crime, the physical act of the crime. Burden of proof. The burden of proof in criminal law rests on the prosecution to prove beyond a reasonable doubt, and the judge in a jury trial will tell the jury that that is the case. It's the prosecution that is bringing the allegation. They must prove beyond a reasonable doubt. What the problem is they don't explain is beyond a reasonable doubt. They'll just explain it, it's a criminal standard, it's a very high standard, and they'll say that it's ordinary English words and it needs no further explanation. Problem is, it usually does need further explanation because what is reasonable doubt to one person may be not reasonable for somebody else. But that's what the jury has to grapple with. It's meant to be beyond reasonable doubt is a lot more than suspicion that somebody has done something. It has to be more than suspicion. It has to be if there's a reasonable explanation, an alternative explanation that the jury find is reasonable or the court finds is reasonable if there's no jury, then it should be not guilty. But if there is, if there is a reasonable doubt, if there's some sort of alternative explanation which is reasonable, then this person should be found not guilty. But if there isn't, then it should be the verdict would be guilty. So a reasonable doubt should bring about not guilty. But if there is no reasonable doubt that this crime was committed by that person, then the verdict would be guilty. It's hard to explain, and the judges do not explain it. But it has to be more than severe, more than extreme suspicion. I can't get my words out. More than suspicion, more than grave suspicion, more than they'll be told suspicion is not a substitute for beyond reasonable doubt. So the prosecution really has a hard task of proving the case. Balance of probabilities is used in AVOs and civil law. Balance of probabilities, it's a less difficult standard of proof. It might be 51% yes, 49% no. The balance of probabilities, the scales can tip in one way or the other. It's much lower standard than the criminal standard beyond a reasonable doubt. Objective seriousness is something that you'll hear in sentencing courts. objective seriousness, how does this type of offence, how does this break and enter compare in seriousness to other break and enters? Has the house been ransacked and has property been destroyed? How much money or property has been stolen in the break and enter? Were people home at the time? Um, what are the circumstances? How does this how does this example of offence compare to other examples of the same offence? Comparing and contrasting others of its type. Is this one more serious or less serious, or sort of on equal footing to other of its type? Not other crimes. So you can't compare apples and oranges. You have to compare the same type of offence. And where does this one rank according to the court compared to others of the same type? And, if it's much more serious, if the facts make it much more serious than others of its type, then you would expect that it may result in a higher penalty, all other factors being equal. So that's what objective seriousness is about, the court comparing and contrasting this offence with others of the same type based on the facts. Precedent is a past case, and it might be an example, which is example of a past case which is used in the present or future cases. Same set of facts, same legal decision, and one case might set the precedent for others. Legal arguments might be based on past cases and examples to try and run the same legal argument this time, the next time. So precedents, so you look up old case law, you look up, sometimes you break new ground, sometimes there's a legal point, there is no precedent, there is no past example of this, and you might be in new territory. So you might be trying to set a new precedent. Future example. Special circumstances is something which is heard in sentencing. It's a sentencing finding which you're asking the court to vary the ratio between that head sentence and the non-parole period of a sentence, and we discussed those words before. So standard sentence will have a prison sentence, standard prison sentence will have 75% of the sentence is in jail as the non-parole period, and 25% of the sentence is on parole in the community. A finding of special circumstances for various reasons, they're not set out in the legislation, will allow the court to vary that percentage. So instead of 75% non-parole period in jail, you might get 60% of time in jail, or 50% of the sentence in jail, and 50% on parole. That's what defence is trying to achieve every time. And examples of special circumstances might be the young age of the offender, might be first time in custody, first time to get a jail sentence, might be the health, physical or mental health of the offender, which makes jail much more difficult for them. Asking the court to adjust the sentence, reduce the time in the community, reduce the time in jail and increase the time in the community on parole. Person may have issues that they really need help dealing with when they get released on parole, like drug addiction, mental health. They might really need extra time in supervision to readjust and reintegrate in the community and deal with those addiction or their mental health treatment. Best place for them might be the community. They're still going to get jail time, but it will be better for them in the community to have more community support dealing with those significant drug or mental health issues. Various factors may result in achieving special circumstances, which again the defence really want to submit to adjust the time in non-parole period and on parole. Victim impact statement is a statement, a letter written by either the victim or the victim's family, if the victim is deceased. It's how the crime has impacted them. And they can read it out, or they can have a support person read it out, or it can be read out by the prosecutor, or it can be just tendered and not read out in court. And it's their chance to have a say about how the crime has impacted them. And they're very powerful and very emotional, hearing those victim impact statements in court. Okay, so then we have words, crimes against the person. Murder, manslaughter. So manslaughter is somebody is being killed, but the intention to kill or to cause grievous bodily harm is absent. Whereas murder involves an intention to kill or to cause grievous bodily harm. So the penalty for murder is going to be much higher because there's intention behind the crime. Manslaughter may be excessive self-defense, killing in excessive self-defense, killing because of substantial impairment, because of mental health or cognitive impairment at the time. Manslaughter may be an unlawful and dangerous act like a punch, which results in somebody falling over and hitting their head on the road and dying. It wasn't intended to kill, but it did kill. So that's a difference between manslaughter and murder. Very important distinction. And that's why the penalties, the lack of intention in manslaughter will result in a lower penalty than for murder. Grievous bodily harm, or GBH, is very serious injury, and there can be debates about that. But something that's permanent injury will be grievous bodily harm, whereas things that can be a bruise will be healed. A bruise will be recovered from. A bruise is not grievous bodily harm. And reckless, somebody can be reckless or intending to commit a crime. Reckless grievous bodily harm or intentional grievous bodily harm, the penalties will be different because the state of mind is different, reckless or intentional. Wounding, often example, knife wounds penetrates the skin. It goes, and it can different depths or lengths of the cut or the wound. Wounding can be reckless or intentional, and again, the penalty will be different if it's reckless or intentional. Actual bodily harm can be ranged from a scratch, a graze, a bruise. It's not going to be permanent. Actual bodily harm is assault occasioning actual bodily harm, AOABH, 5-year maximum penalty in New South Wales. Common assault, 2-year maximum penalty in New South Wales. It doesn't have to be physical. It can also be verbal. A threat can be an assault, a verbal threat. Spitting can be an assault as well, is a common assault. Putting somebody in fear is what an assault is about. It does not have to be physical. Choking and strangulation, very serious. Those are intentional choking without consent, strangulation. They can range. Strangling somebody can result in an attempted murder as well. So the consequences of choking and strangling, people can die from it. People can receive grievous bodily harm as a result of the injuries, that sort of thing. So there are police are increasingly laying charges involving choking and strangulation. A fray is where 2 or more people basically get into a fight which could cause reasonable persons in the community to be in fear. Oddly, an affray can even be done when nobody else is in sight, but the charge can still be laid. So that's an affray. Property offences, theft, larceny. There's all different types of larceny. Larceny by employees, larceny, one person stealing, permanently depriving somebody else of property, stealing. When you look through the Crimes Act, there's all these types of larcenies, and larceny by clerk, stealing cattle, all types of crimes, rural type crimes, crimes in, more urban type, city type crimes, but there's lots of types of larcenies in the Crimes Act 1900, New South Wales, quite interesting, and they get updated, etc. Shoplifting, steal from person. Example, somebody gets their bag snatched on the street. That might be a steal from person. If there's a threat involved, it can be a robbery. Robbery in company, more than one person is involved in the robbery. A threat can be an actual, like a threat of violence. There could be actual violence or a threat of violence. Break, enter, and commit serious indictable offence. For example, stealing. A serious indictable offence by definition is a 5-year maximum penalty offence. Most of these are break and enter and steal. Larceny carries a 5-year maximum penalty. Fraud or obtain benefit by deception, often, Centrelink frauds, frauds by using a stolen credit card, internet frauds, things like that, stealing money, pretending to be somebody else, identity theft, identity fraud used to pretend you're somebody else to deceive somebody and gain some kind of financial benefit from that. Fraudulent documents, and that often, there's all these warnings about fraudulent forged documents and things like that in real estate transactions and all of that sort of thing. And internet and AI, artificial intelligence, is just going to increase the capability and increase the incidence of that kind of fraud, I'm afraid. Trespass, unlawful entry upon closed lands is a fine-only offence. It's a fine. So, so they're property offences. Drug offences and alcohol. Alcohol is a drug, but drug and other alcohol, alcohol and other drug offences. Illicit drugs is a Drug Misuse and Trafficking Act. So you've got your heroin, your cocaine, your methamphetamine. There's a whole heap of prescription medications, which if people are in possession without a prescription, then they can be charged for being in illegal possession of medications, which should be under prescription. Possess prohibited drug is a crime. Supply prohibited drug is considered worse than possessing it, as the maximum penalties will be higher. Or deemed supply is when you're in possession for the purpose of supply. Police allege that the quantity that you're in possession of is too much for personal use. Personal use of a drug is a defence to deemed supply. If a person is defending the case that way, then they really need to sort of give some evidence about their drug use habits and to prove on the balance of probabilities that they are not in possession for the purpose of supply. Sometimes supply might be indicated by resealable plastic bags, set of scales, a book with or phone records with people depositing money in, lots of small deposits suggesting that these are customers buying drugs, things like that. So police will build a case of deemed supply or drug supply based on other evidence, and then the person may have to explain, well, what is the list of names? Why do you have all those plastic resealable bags? The quantity of drugs, the tools used to divide it up, and etc., etc. So importation, that's a Commonwealth offence. Importing drugs into Australia will be prosecuted by the Commonwealth. Different weights of drugs result in different thresholds, like trafficable quantity, small quantity, indictable quantity, large commercial quantity, will result in different maximum penalties. The larger the amount, of course, the more serious it is. Merit program or interlock programs are programs to try to divert people from jail, certainly. Merit program, go away, local court, go away, do this course, come back and get sentenced. If the person has completed the course, then it's a magistrate's early referral scheme, and if they complete the course successfully, then they may avoid a jail sentence. Interlock program is not being able to drive without having that device on the car. It's because there have been charges in the past of driving under the influence of alcohol or drugs. And you can be fined if you are caught driving without that interlock device on your car if that was your last penalty in court. So driving under the influence of alcohol or drugs, a prescribed concentration of alcohol, low range, mid range, high range. There's different, if somebody's a learner driver, if somebody's a provisional licensed driver, they will have different rules they should have 0 percentage. And then there's different, 0.06 will be low range, 0.05 is threshold, 0.06 will be low range prescribed concentration of alcohol, that sort of thing, and different penalties in terms of fines, disqualifications. A high range PCA is more serious and can result in jail as well, especially if there's a crash, if somebody dies as a result of the high range drink driving. They're local court offences. The drink driving, etc., is local court. Importation of drugs will be district court. Sentences, we start with the worst one is full-time prison, and a sentence of imprisonment for life in New South Wales means a person will die in jail. There's no non-parole period. They will not be released on parole. They will die in jail. I know some other states and territories have life, but with a non-parole period, and they'll be on supervision for the rest of their life. But New South Wales, that's not the case. Life will be no chance of parole, and the person will die in jail. A prison sentence is structured in a way of, again, the non-parole period and the parole period. Part of it's in jail, part of it's under supervision in the community. And if you commit an offence while on parole supervision, you then affect your chance of getting bail. And that risk of, committing a new offence while on bail, it really affects your chance of getting bail. If an offence, it makes it show cause and it causes real problems on getting bail the next time. An intensive correction order, or an ICO, is a jail sentence. To be clear, it is a full-time jail sentence, but it is served under supervision in the community and usually with more conditions. There might be a treatment condition like go and get mental health treatment plan in place from your GP. It might be abstain from alcohol or drugs. There'll be other conditions. Or it might have a community service component, which can only be achieved if Community Corrections write a sentence assessment report saying this person is suitable for community service. So an ICO also has a limit. for one charge, it's a 2-year maximum intensive correction order. And if somebody breaks the rules by a new charge or fails to be supervised, fails to turn up to appointments, etc., community corrections can write a report to the parole authority and have that intensive correction order revoked, and you can go back to jail for the length of the remaining intensive correction order. So the consequence of breaching it is severe. And for more than one charge, like 2 or 3 or 4 charges sentenced at the same time, the limit can be 3-year intensive correction order, which is, as I said, is a jail sentence, but served in the community under supervision. Community correction order, or CCO, is not a prison sentence. The local court or the district court can give these. They're a bit more rare in the district court, certainly rare in the Supreme Court, because these are usually for less serious offences. So usually this will be given in the local court, but not impossible in the district court. They're served in the community. They do have a conviction, goes on the record, of course, has some conditions, might be abstained from alcohol or drugs. It may involve supervision by community corrections. If a person breaches any of the conditions, then they can be brought back to court to be resentenced. So that's the consequence for breaching. And they can be up to 3 years. Conditional release orders, CRO, are usually not going to get this in the district court. This will usually be a local court thing. It's not a prison sentence. It's intended for less serious crimes, may carry conviction or it may not. And there'll be conditions. Maybe supervision, may not be, but there might be conditions to, be of good behaviour is always one. So committing a new offence while on one of these results in being called back to court and perhaps having the conditional release order revoked and resentenced, depending on what the breach is. Fines is a monetary penalty, and we no longer have magistrates here, but so now they're judges, but fines, some crimes are fine only as well, like that unlawful entry upon enclosed lands, and the legislation will have what the maximum fine can be. If my client's unemployed or in jail, then a fine's really not going to be practical if they're struggling with, but people can apply to pay fines by instalments. They can go to the registry and make an application to pay fines by instalments. At the end of the day, a fine is still better than jail sentence or it may also still be much better than a community correction order that drags on for 2 years, but not everyone is in a financial position to cope with paying for a fine. Section 10 subsection 1A of this is the Crime Sentencing Procedure Act. That is where a charge is dismissed and no criminal conviction. That will usually, you might get one chance at that. Somebody with no criminal record, rather low level offending. It's really a chance, because criminal convictions obviously affect people traveling or certain jobs, etc. as well. But you usually don't get that chance the second, third, fourth time around. Section 10 capital A is a conviction but no other penalty. No fine, no jail, conviction with no other penalty. Specific deterrence is a principle in sentencing where the judge is giving a sentence which you're really trying to deter this specific person, this individual, from reoffending, giving them a punishment that's going to discourage them, that individual, from coming back before the court reoffending. Moral culpability it's a It's a responsibility, culpability coming from the Latin mea culpa, my fault. It's fault, it's responsibility, it's blameworthiness for the crime. And if somebody is mentally ill or a situation where they had an extremely disadvantaged upbringing where parents took drugs, for example, in the home, they're brought up around that in it from a young age, they may be less considered less morally culpable than somebody that had every advantage in life. So judge will make a finding about how responsible or blameworthy is this person for the crime. I've explained this before, but again, full-time sentence is structured um, traditionally 3/4 in jail as the non-parole period, 1/4 on parole. Special circumstances, for whatever reason, young, old, sick, need time to deal with addictions in the community, various reasons, many reasons, isolation in jail because of language barrier, family is not in the country and you can't get visits. Any of these reasons might achieve a finding of special circumstances to justify varying that ratio between non-parole period and parole period, reducing the time in jail, increasing the time on parole. A fixed term is usually a short sentence, might be 6 months or less. There's no non-parole period. And a magistrate or sorry, a judge may just give you a 6 month sentence or a 1 month sentence for something quite minor, but still deserving of jail. But 6 months or less. Sometimes when somebody's already in jail for something else and they're going to be in jail for a long time, sometimes the court might just give a quick fixed term sentence or that 10 capital A because there's really no practical point in putting somebody giving somebody a fine if they're going to be in jail for quite some time. They're not going to be able to pay the fine. So fixed term, yeah, there is no non-parole period and they'll come out and they won't be on parole supervision. So that brings us to the end of our words.
Thank you, Helen. That was absolutely amazing. And I learnt things even. So that was really great. We have a couple of questions, but I think we might try to answer them as we're 17 minutes over time. We'll try to answer those via email.
Yep.
And we've also tried to answer as we went along. But lots of thanks for you and lots of praise. Just for information wise, I will say that there are resources on our website where you can look up legal words, which really helps. It's not the same as a Helen seminar, but you can certainly look these up on our website. It's under ways to get help and it says legal words. Also, we do family law and civil law, so we have those words up there as well, and we have translations on our websites as well. We are the Law for Community Workers, and we do newsletters, podcast, recorded webinars, which was today. We have upcoming events, and you can request a workshop on our section of the legal aid website. Mostly, thank you so much for joining our webinar, and special thanks to our presenter, Helen Shaw. You'll receive an evaluation survey and we appreciate your feedback.
Yeah, we look at the feedback to make improvements and to also add in words which we didn't have because there's always excellent questions. And I will look at your questions and email back to you. If you do see me at court sometime, please come and say hello. Please don't be shy. I love it when people come up and because you've recognized me on one of these webinars and you come and say hello. And if you can, please join us on the 6th of May for our talk specifically on sexual-based offences, coercive control, and AVO words and stuff like that, because that's really important as well in criminal law. And it's some of those laws are more new, and you may or may not have had experience interpreting, but I'm sure you will get increased experience as police lay more of those sorts of charges. Again, to interpreters, bilingual, trilingual, multilingual workers, you're awesome. And we can't do our job as lawyers without you when we have clients who um, don't speak English or aren't confident in English. And if I can't speak their language, then we need you. So your work is absolutely invaluable and totally appreciated. And yeah,
Mm,
and don't
well
let the
said.
court silence you, because you have to be heard in court to be able to do your job properly.
Yes. Well, we'll leave you now and thank you very much again. And you'll receive an email from us with all information that you need. Thanks again, Helen.
Thank you very much. Yep, thank you very much to Melanie as well, and to everybody.
Thanks. I'll just end the session.
Cool. Thanks so much.